Hello friends, in the series on the income tax cases, today we will discuss the case of Principal Commissioner of Income Tax and another versus MSPL Limited. This case has been reported in 454 ITR at page number 280. The matter has been decided by Supreme Court and the date of the judgment is 25th April 2023. Friends, the purpose of discussing this case is that in our country, due to a number of the high courts and due to a number of the income tax tribunals, there is a lot of litigation on this point also, that what is the right jurisdiction for the assessee to go into the ITAT or for the high court, and due to which a lot of time and energy of both the department and the assessee gets wasted. The general rule is that the jurisdiction is decided for the purpose of CIT appeal, for the purpose of ITAT, or for the purpose of determining that which high court should the assessee go, depends where the assessment order has been passed. In this case, the search was conducted on the assessee. The assessment was completed in the Bangalore by the Deputy Commissioner of Income Tax, against which the CIT appeals were filed in the Bangalore CIT appeal. When these cases were decided by the CIT appeal Bangalore, the matter carried to the Bangalore ITAT. When the matter was pending before the Bangalore ITAT, the president of the tribunal transferred these cases from Bangalore ITAT to the Bombay ITAT. It was the contention of the assessee that my jurisdiction of the tribunal is Bangalore ITAT and not the Bombay ITAT. But the cases were transferred. So the assessee moved to the Bombay High Court by filing a writ petition that this transfer is not valid, this transfer is not as per law, and my cases should be heard by the Bangalore ITAT. So on this point, the Bombay High Court said that the contention of the assessee is correct because the assessment orders have been passed in the Bangalore and the CIT appeal was also the Bangalore. So the right jurisdiction for the purpose of the ITAT is Bangalore ITAT and not the Bombay ITAT. But the department was not happy with the judgment of the Bombay High Court, and I must say here that at this junction I feel that the department has a great appetite for the litigation. I do not think so that there is any prejudice to the department that when these cases will be heard by the Bangalore ITAT and when there is a settled law, but just for the sake of going into the appeals, even in these cases the department moved to the Supreme Court that the judgment of the Bombay High Court is not valid. But the Supreme Court also held that by following the judgment of the Supreme Court in its earlier decision in the case of Principal CIT versus ABC Papers Limited 2022 447 ITR at page number 1, that the decision given by the Bombay High Court is correct. So the Supreme Court also upheld that the right jurisdiction of the assessee in this case was the Bangalore ITAT and not the Bombay ITAT, and the transfer done by the president of the ITAT is not justified. My humble submission in this case is that when the assessee filed the writ petition in the Bombay High Court, when this case was transferred from Bangalore ITAT to Bombay ITAT, so the jurisdiction of the assessee was not the Bombay High Court but the High Court which is covering the Bangalore. So, but this point didn't came for the consideration of the Bombay High Court or the Supreme Court. So the matter was decided in favor of the assessee by upholding the order of the Bombay High Court that the right jurisdiction of in this present case is Bangalore ITAT and not Bombay ITAT. At the end of this video, once again I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus MSPL Limited and this case has been reported in 454 ITR at pin number 280. The matter has been decided by Supreme Court and the date of the judgment is 25th April 2023. Thank you, friends.